Hi everyone! Today I am going to talk about the sovereignty of a state and how territories are acquired. Stay tuned to know more. Sovereignty has shaped the world for centuries. It is indeed the product of history. The concept of sovereignty was first introduced through the Peace of Westphalia in 1648. This has brought to an end the 80 years wars between Spain and the Dutch and the German phase of the 30 Years' War. Sovereignty ensured that the government of the state has ultimate authority over everyone and everything that are within the country's border, and whoever and whatever that happen to be in the country. Internationally, sovereignty creates equality among the states all across the globe. It requires all countries to respect other countries' borders. Sovereignty of a country also stops others from interfering with their domestic affairs. The expression acquisition of territory is usually employed as meaning the establishment of sovereignty over a given piece of land. There are four ways of how territories can be acquired. Firstly, its occupation. If a territory where there is no sovereign, then a territory can be occupied by exercising power. Next, accretion. If geography is changed due to natural cause. Thirdly, cession. Land acquired by war or by voluntary act. Lastly, prescription. Prescription is the result of peacefully exercise of de facto sovereignty for a very long period over a territory.
Hi, my name is Sakina and I am going to talk about jurisdiction. So what is jurisdiction? According to Cornell Law School Dictionary, jurisdiction is the power of a court to judge cases and issue orders. It also refers to a court or government agency that may conduct its authority within certain territories. It is important to determine before filing a lawsuit on which court has the jurisdiction. There are three types of jurisdiction: prescriptive jurisdiction, executive jurisdiction, and adjudicative jurisdiction. Firstly, prescriptive jurisdiction. It is the power of a state's legislature to create, amend, and prescribe laws that bind all people, property, territory, or events within its territory. The state may extend the jurisdiction outside its borders through international treaty or customary law. Also, the legislature created must satisfy the constitution of the state. If not, it is not considered as law. In UK, under Section 72 of the Sexual Offences Act 2003, any British citizen who commits sexual offences against children in foreign countries will be prosecuted. For example, in 2016, a British citizen, Richard Huckle, was convicted for 71 counts of sexual assaults against children in Malaysia. He was imprisoned for a minimum of 21 years. Next, executive jurisdiction. It is the capacity of the state to act within other countries' border. State officials cannot carry out their executive tasks in the territory on another state unless that other state expressly consents or it was acting under some other principles of IL or some authority given. State cannot enforce its laws on foreign territory. The term executive and state officials do not only refer to ministers, it also may refers to police and army. For example, if a criminal from Indonesia escaped to Malaysia, Indonesia cannot simply send police or soldiers to cross the Malaysian borders without Malaysia's permission. Lastly, adjudicative jurisdiction. It is the power and rights to hear and settle disputes by national courts, tribunals, and other bodies. It mainly focuses on whether the court has the power to provide a forum to solve the dispute, not the result of the dispute. There are no limits for jurisdiction on civil cases except for criminal cases, sovereignty, and diplomatic immunity. For example, the Lockerbie case. In 1988, Pan Am Flight 103 was bombed and crashed at Lockerbie, Scotland. The Scottish courts allowed the trial of 2 Libyan suspects to be done in Netherlands, but according to Scots law.
Hi guys, my name is Azufar,
And I, Robianto.
and today we're going to show you some principles of jurisdiction.
Firstly, we need to take a look at the list of principles of jurisdiction, and we are going to explain it afterwards.
First, we have territorial principle,
Nationality principle,
passive personality principle,
while fourth is the protective principle.
and lastly is the universality principle.
And now on to the next step is the explanation. Territorial principle is a principle that allows a country to deal with crimes within their territory. This principle also has been changed to be able to allow officials of one state to act in another state on certain circumstances. Example of this: when there is a country then the people inside the country committed a crime that reside in this country, then the country is able to claim jurisdiction over the people that committed the crime within the territory.
Next is nationality principle. Nationality principle is a principle that allows a country to be able to exercise criminal jurisdiction over any of people in this world that has its nationality if they do any criminal offenses regardless their territories they are residing. Example of this is the adoption in Britain of the War Crime Act 1991, where this issue is to confer jurisdiction on United Kingdom courts regarding the grave violation happened in Germany during Second World War.
Thirdly, we have passive personality principle. This principle tends to happen in a limited amount of cases. This principle is used to claim jurisdiction on another country's citizen or nationals for offenses committed abroad that has effects on the country that is trying to claim jurisdiction, citizen or nationals. The example is United States once used this principle to prosecute and arrest a terrorist named Manuel Noriega from Panama that had been committing crimes such as cocaine trafficking and money laundering.
Next, there is protective principle. Protective principle is giving a country ability to claim jurisdiction over offenses that occurred outside the territories that is injurious to the country's security or vital economic interests. This often happens to cases involving currency, immigration, and economic offenses. The example of this case is Joyce versus Director of Public Prosecution, whereby the defendant was an American who held British passport. And after the outbreak of war between Great Britain and Germany, he therefore from Germany broadcast talks in English hostile to Great Britain.
Last but not least is the universality principle. Universality principle is a principle that is actually used when there is an individual or group committed offenses against the international community interests such as genocide, war crimes, and inhumane. All states have jurisdiction to this matter, irrespective of the nationality of the victim or the perpetrator and the location of the offense. Example of this principle is the Holocaust, where Adolf Hitler clearly did massacre on Jews, and thus he committed genocide.